Shooting or throwing a deadly missile in Florida is way more common than you think, and we're going to go ahead and break it down right now. I'm attorney Adam Rossen with the Rossen Law Firm, and we're going to dive into another series on some Florida statutes, some Florida crimes. Okay, and this is one, it's kind of unique to Florida, but we see this quite often. It's called shooting or throwing a deadly missile into an occupied, whether it's a vehicle, aircraft, house, okay, all those type of things. And this is really uniquely Florida, the way that it's written and discussed. And the history dates back to the early 1900s in Florida. You know, Florida was kind of the wild, wild South in some ways. And there were a lot of train robberies, attacks on railway cars, which were pretty common, you know, in rural Florida, because Florida was basically a very rural, deep South kind of place way back when. And so this law was created to really protect, you know, workers and passengers on our train system, which was going all the way down, you know, Henry Flagler style, all the way down to Miami. And then we have our canal series and the intercoastal and the different lakes in Florida and rivers. So all those things, that's where really this came from. And then over a few years, it was expanded to include, well, cars, buses, boats, aircrafts, and they kept this missile language, right? So we're going to be talking about, well, what are the elements of this crime? What is a missile, deadly missile? Really, we'll just go deep dive into this, because the odds are if you're watching this and you're wanting to know about this, well, then maybe you or someone you know has been charged with this crime. So let's get right into it. Now, as in all crimes in Florida, they have to be proven beyond and to the exclusion of every reasonable doubt. So remember, reasonable doubt, okay? To put a number on it, it's about 90 to 95% guilty. We have videos on reasonable doubt. I'm going to want you to go ahead and watch those. We'll link them up to some FAQs about that. But really understand that to be proven beyond a reasonable doubt, it's not 100%, but the prosecutors, the police officers have to convince a jury that you are about 90 to 95% guilty. Okay, so always keep in mind is when we're defending cases, if we convince a jury that you're probably guilty is 51, 55, 60% guilty. And that means the jury must find you not guilty. Watch that video for some more information. So now let's go into element number one, okay? It's the defendant did one of the following, which would be shooting or throwing a missile that would produce death or great bodily harm, okay? Or they hurled or projected or threw a stone or other hard substance, again, that would produce death or great bodily harm. Or they shot a firearm. So what's happening in this statute is it could be something that you throw, it could be something that you shoot. We've seen bricks, cinder blocks, you know, knives, right? Obviously shooting a gun, okay? It has to be something that's really dangerous and that could be capable of causing death or serious bodily harm to a person. And when we look and evaluate that, right, if we're talking a tiny little pebble, if we're talking about a crumpled piece of paper, well then absolutely not. That's not something that can truly hurt or kill somebody. But we also need to go into the analysis of deadly weapon. And what the law says on this analysis is that, you know, a firearm, for example, is per se a deadly weapon when you shoot a gun. Okay, but there's a lot of things, right? Would scissors be a deadly weapon? Well, usually the answer is, well, how was it used, right? Would a small pocket knife, maybe a Swiss Army knife that's this big, would that be a deadly weapon? Well, it depends how it's used. What about a frying pan, right? Is a frying pan per se a deadly weapon? No. But what about the manner in which it's used? So when we're talking about, you know, this deadly missile language, it's the exact same. We're looking at what you threw, okay, or hurled or shot, right? And the manner in which that object was used is going to be one of the things that we'll fight about in court of, well, could that have actually produced death or great bodily harm? Now, element two is the location, okay? And so this has to be done, you know, at, within, or into a public or private building. Okay, so it could be a house, could be an office, could be, you know, right, things like that. A public or private bus, okay, a train, a locomotive, a railway car. Now we're getting back to the old school 1900s kind of stuff. A vehicle, okay, of any kind. So just a car, an SUV, and these are the things that we're going to see a lot of these type of things. Road rage incidents, maybe on 95 or the turnpike or just the streets, where we've had clients that pick something up and throw something at another vehicle. Obviously, shooting at a car, yes, of course, okay, but then it doesn't always have to be a gun or a bullet. A boat, a vessel, a ship, a barge, or an aircraft. Okay, so it really encompasses moving vehicles, right, of pretty much all types, and houses, buildings, commercial, residential, industrial. Okay, so it must be a location where people could reasonably be hurt by that act or would be. And the third element is, well, the mental state, okay, what we call the mens rea of the case. What's the intention? Okay, it has to be proven that this act was done wantonly or maliciously. So it cannot be accidental. It must be something that is pretty much intentional or so reckless, right? Reckless disregard of safety. Okay, so it's either intentional or a reckless disregard for the safety of others. So let me give you two scenarios. So scenario one, you're driving, right, next to another car. There's a road rage incident. You look at somebody and there's gestures and maybe you flip them the bird, they flip you the bird, and you pull out a gun and you shoot deliberately at that person. Well, there'd be a few different crimes that you'd be charged with, maybe attempted murder, right? Maybe aggravated assault, but also shooting a deadly missile into an occupied vehicle. A different scenario, this car kind of weaves and cuts you off, but you don't know how many people are there. You kind of just pick up your gun and say, well, I just fired at the car to just kind of scare people. It really wasn't at any person in particular. It was just at the car just to, right, let them know, hey, you're messing with me, don't mess with me. Well, that's more of the reckless, the wanton and willful disregard rather than the intentionally at a specific person, okay? Either way, that would solve the element of this crime, okay? And so that just also goes to show that you don't have to specifically shoot at a particular person. And in that second scenario, it might not be attempted murder. It might not be aggravated assault, but it would definitely fall under the shooting a deadly missile into an occupied vehicle. All right, so to recap everything, there's really three elements of this crime. The first element is shooting or throwing a deadly missile, okay, something that can create great bodily harm. The second element is, well, it has to be in a car, a boat, a train, or another type of structure like a house or a commercial area. And the third element talks about the mental state of, well, was this intentionally done or wantonly or maliciously done? Those are the three elements. Now, this is a very serious charge in Florida. It's a second-degree felony. That means it has a max punishment of up to 15 years in prison or 15 years of probation or any combination of those two. It's a very, very serious crime, okay? We're going to talk in the rest of this series about the penalties, the defenses, and going through kind of the court process. So go to the next video, keep following us for more. If you have any questions, put it in the comments. You can always give us a call, 754-206-6200.